Welcome to this special telecast on NewsX. I'm Uday Pratap Singh. Starting today, we are launching a campaign called 5 Grams of Justice. In September 2020, a 25-year-old intellectually disabled woman was brutally raped at Khadaka village in Maharashtra's Amravati. The rapist was convicted and an immediate victim compensation was announced. However, the District Legal Services Authority did not disperse the compensation. The victim's mother, who was a sole caregiver, struggled for years to get the money before passing away in May 2024. A year later, the victim died too. At the time of her death, only a partial amount of the compensation has been released. The Supreme Court has now pointed at significant lapses in victim compensation process. We're calling this campaign 5 Grams of Justice because not only is victim compensation a statutory right, but it is also a bare minimum. While the justice process in this country is a constant matter of debate, compensation needs to be quick. Over the next few days, we would be putting attention on many such cases where compensation has been delayed with the intention of solving this problem. Joining us live is Gaurav Kumar Bansal, rape case petitioner from Amravati. Thank you for being with us today, Gaurav. How shocking and sad is this that despite the fact that the legal guardian of the victim and the victim herself have died, only partial compensation as ordered by the court was released?
See, this is really a sad part, and that's why we filed this petition and requested the urgent intervention of this on the apex court of the country. Point one, that the compensation is not a charity; it's their right. Point two, that these incidences is happening because of the lapse of the security and other parts and the lapse by the police. Point three, that many times what is judiciary is also overburdened. We have to take note of all this fact also, that judiciary is highly overburdened, and that is why the Supreme Court itself has directed that now the time has come that all the high courts has been requested to intervene and has been requested to direct the district judge and the session judges who are taking care of who are adjudicating the criminal petitions to check that whether the victim compensation has been released on that time. Plus, that as far as the judgment, when the judgment is there, so it's the court is of the view, and earlier this honorable court, the Justice Nagaratna bench has recently ordered one same case such kind of an order, that as far as the victim compensation under the victim compensation scheme is concerned, that has to be paid as soon as possible. So this is the second round where the Supreme Court, the Honorable Apex Court, is again requesting the intervention of the high courts of all of this country, and are requesting that as far as the victim compensation is concerned in the POXO cases, in the women sexual abuse cases, please provide the same on time.
Okay.
And that is why.
Absolutely, because, Gaurav, while we've already lost the victim in this case, and that is really, really unfortunate, we need to ensure that more such victims do not face the same kind of apathy with them not getting the compensation, which is the bare minimum that they deserve.
Exactly. But at the same time, we also have to look that many times what is happening, that as far as the victim compensation scheme under section 357A, there are also other victim compensation schemes, like in Maharashtra. There are two schemes, one Manodaya scheme as well as this victim compensation scheme. What happened, that what we found in this case, as far as the Manodaya scheme is concerned, the victim not only failed to get the compensation in the 357 victim compensation award, but as well as in the Manodaya scheme. So this, and one more thing, this girl unfortunately was from the neglected community. She was a mentally retarded. Among the vulnerable, there is a neglected community, and that is the persons who are the mentally ill, who are the disabled, who are the mentally retarded. And in this case, we have also proposed by way of the petition that that time has now come to take this thing with the paralegal volunteers. What will be the consequences, and how basically how the mechanism will work when the person is a homeless PMI, homeless person with mental illness. And there are cases in our country that person with mental illness are not only vulnerable, they are also subjected to many many tortures, and rape and sexual abuse is one of them. So we have also requested the intervention of the Honorable Supreme Court on two aspects: victim compensation, plus the issue regarding the how to deal with how to provide the bare minimum in such circumstances to the persons who are vulnerable or the neglected community. So that is why the Honorable Supreme Court has requested the intervention of the High Courts.
Absolutely. Let me also ask you, Gaurav, now about this petition that you filed. What is the current status of it and what are you seeking?
So basically, we have two or three prayers in this petition with regard to that there has to be a kind of a online board portal plus time bound dispersal. That because time bound dispersal of the bare minimum is the most fundamental thing which we are seeking in this petition. And as far as we have basically portrayed whole of the circumstances, the Jyoti, who is the petitioner, she helped. She is a basically she's an advocate and she's also supporting such kind of families. So it was Jyoti who basically traced out this person, and then she tried to have a meeting with the DLSA, District Service Legal Authority persons, and then they requested their intervention. But at the same time, what happened that the mother as well as the daughter are no more right now. And after their basically when they passed, unfortunately, then the compensation got released. So this is something which also pain us, that there is a amount, there is a victim, but what is happening that just because of a gap of mechanism which is not here, the persons are not getting that bare minimum.
Absolutely. I appreciate you joining us, Gaurav, with your perspective on this story. Let me also join now Gurmukh Singh Arora, Supreme Court lawyer, who's joining us live in the broadcast. Gurmukh, what do you make of this shocking instance of this victim in the Amravati case, who till her death received almost none of the compensation, just a partial amount?
So, what I personally think is that this is not just a tragedy for the whole country, but it also is just like a mirror which shows all the gaps which we all have, and the gaps which every victim is facing today to have the bare minimum of the compensation which is their right. So, specifically, we have to first understand that whenever a crime is committed in this country, it is not the individual who is facing anything, it is not against any individual, but it is always the society who faces a crime at large, and it is always the failure of the state, because under the constitution it is the duty of the state to protect its citizens. So whenever a crime is committed, it is the failure of the state which is prima facie seen that the state has failed to protect its citizens. Now in these type of cases like rape, acid attacks, and all these heinous crimes,
Yes.
the bare minimum which the state can give is compensation. Now compensation is a part of justice. Justice is a twofold system in these case scenarios. The first system is to make sure that whosoever the accused is, he or she is convicted at the earliest. Number one. Number two is that since the inception, whenever a crime is committed, the victim should be compensated with a bare minimum of amount. Now, amount can never be the only thing with which a
Yes.
personal trauma or an emotional trauma can be satisfied. It is only
Okay.
the economical
Okay.
factor
Let me
which
also
can
bring in
be.
Ikrant Sharma, Supreme Court lawyer, also for his perspective. Ikrant, what do you make of this case, and what are the lessons that hopefully we should draw on what not to do? In this case, of course, the victim has died. But how do we ensure that this doesn't happen in other cases?
Now, as far as for this case is concerned, I think this is a whistleblower, and this case, the suo the PIL, which has been filed in the Honorable Supreme Court, and Honorable Court has taken it on a serious note. And these sort of cases, I think this is not the first case where it has happened. There must be so many cases which where the victims who has suffered a great cruelty are not getting the rights what they are entitled for that. Now, as far as the way the sex victims are concerned, the sexual assaults are concerned, the rapes are concerned, there are so many cases. Now, the thing is, it has to be noted down, and the point has to be taken that who is at the fault. Now, my other co-panel advocates has already reflected that there is a delay. When there is a delay, the delay is a denial of justice. If we go through the system of the legal system and the jurisprudence and the trial procedures, there is so much of delay. which really hampers the justice. First thing. Second thing is even the compensation amount is concerned. The compensation amount is not being granted to the rape victims, whereas the orders. What I just suggested is, because the suggestions are already been provided by the Honorable Supreme Court, and Honorable Court has taken it on a serious note. What I personally feel about when the orders are being passed, when the conviction is there, and when the complaints are already been filed, when the complaints have been there, the compensations are there. Now the compensation amount has to be specified, and the state government and the central government needs to work according to that order. Now the order should be specific. Even if we go through the trial court orders, the compensation, though it's been there, the compensation amount has to be given. But what sort of amount has been there? There are two parallel things. First is compensation, and the second thing is rehabilitation. Compensation is only pertaining to the monetary part. Now, as far as rehabilitation things are concerned, there has to be a policy. There has to be certain benchmark system, so that there has to be rehabilitation, so that the victim should go into the society, should be an independent, and should not be at the mercy of the people and the society. And she should not be victimized, or she should not be targeted. Now, this judgment has come, and Honorable Supreme Court, I really appreciate this
Okay.
verdict, and I just really
Yes.
appreciate it.
All right. Thank you, Ikrant and Gurmukh, for joining us with your perspective on that story. Let's take a look now at the process of victim compensation as mentioned in Section 396 of the BNSS and the statistics as far as victim compensations are concerned. Let's quickly tell you what the current Section 396 of the Bharatiya Nyaya Sahita really states. So the state level scheme is this: the state government is responsible for preparing and of course implementing the victim compensation scheme. This is a state subject in the state level schemes that exist. Also a statutory right. It in fact currently reserves the victim's right to receive compensation for any loss or any injury suffered. In fact, the purpose is to provide funds for victims and their dependents who require compensation. And the role of courts is that the trial court or sessions court recommends to the district legal services authority, state legal services authority, for this process to be implemented or carried out. So, a victim can apply, of course, if the offender is unidentified. Also, if the victims can directly, of course, apply also for this. Let's just hold that, please, before we, of course, move it on. And the role of legal service authority is, if the offender is unidentified, then victims can directly apply to the DLSA or the SLSA for this compensation. Now let's tell you about the statistics with regards to the national victim compensation and how things stand as of now. So data in 2024-25 says that applications received by legal service institutions pertaining to compensation were 12,532. Applications which were directed by the court were 14,385. And if we move to the next slide, we will tell you also about the total applications then and the ones decided. So total applications 26,917 and applications decided 27,011. Applications pending 14,129. Total compensation awarded about 484.67 crore rupees. So that's the statistics as far as the current state of affairs is concerned. Let me also bring in at this point Jyoti Praveen Khanda Posle, who is joining us live, petitioner of the victim in the compensation case. Jyoti, what can you tell us about the 2020 Amravati rape case? What had happened then?
So there was one 25 years mentally challenged woman, and she used to stay with her widow mother. in one particular village of Amravati district.
Yes.
And she went to her grandparents' house for one puja, and there she was with her widow mother. And as there was a puja in the village, the mother was chit chatting with neighbors, and there one of the neighbor who knew that this girl is mentally challenged, so he took her beside the hut or beside their juggi, and he committed sexual assault on her. And as she is mentally challenged and unable to speak, she only she could only pointed out towards the hut of that particular perpetrator, accused person, and her mother found that there was a brutal sexual assault that has been inflicted on her daughter. So this is how the case, her mother identified that she has been sexually assaulted.
What happened to the convict and what was the compensation ordered, Jyoti?
This case was aptly registered by the victim's mother, and case was before the Honorable District and Session Judge number 3 of Amravati District Court, and the accused was convicted, and also the district court, they ordered compensation for this particular victim's rehabilitation under the Manodharya scheme of Maharashtra state, and this compensation was of 3 lakhs rupees.
And what struggle had to be done to receive the compensation?
So her mother was 51 years old at the time when this offense was committed against her mentally challenged daughter, and the case took 4 years to conclude. And then when there was an order on record by the district sessions court that she needs to be given compensation. So in Maharashtra, we have this practice that 25% of the compensation has been granted as a interim compensation, and that 75% compensation is being kept in the fixed deposit under the Manodharya scheme. And as Manodharya scheme is for the minor victims of sexual assault, the District Legal Services Authority waits till the minor victims complete their age of 18 years of old, and therefore they keep this money in the FD,
Yes.
so that the families should not, invest this money in any other purpose than the rehabilitation of victim of crime. Similarly, the same logic applied to this case. However, this victim is 25 years old and was in need of urgent money because her mother was unable to take care of her because of her own illness. So the mother was struggling to get that money even after the concluding of the case. So she came to me after referral from the public prosecutor. So public prosecutor referred this lady, the mother of the victim, to me so that I could help her in getting immediate compensation after the disposal of the case. So I helped her a lot, and we took her to the District Legal Services Authority for asking for the compensation to appoint a nurse, as she is unable to take care of this 25 years old victim who was severely ill at that time. So then we made two representation before the district service legal authorities for releasing that 75% of compensation which was kept in the FD. And me and the mother of victim, we tried to convince the authority that this compensation is needed right now for the medical purpose and for the appointment of a nurse in her case.
Okay, let me also ask you then about, in any case of this brutality, victim compensation is the bare minimum. Why then was the victim not given that? Why was she denied that?
So it's a very grave question at the field level, and we are struggling with it. We means all the victims are struggling with it. Where when we talk about Manodharya scheme, the 25% is directly kept directly given as an interim compensation. Well, rest of the 75% is kept on a hold so that victim should not turn hostile or he should support the prosecution, which is correct in few cases. but the compensation under Manodharya is still bare minimum. And in my opinion, according to according to the case realities, it has to be granted. Right, for this particular victim, the medical assistance and appointment of the nurse was very very important for her and her mother's survival, and it was making no point in keeping that money in FD, fixed deposit, which was anyways not benefiting the victim, which was meant to benefit the victim herself.
And how many such cases have you studied where victims have been denied compensations? What were the reasons for this?
Uh, I have seen multiple cases where I have not only studied but I have worked with them, where few cases are denied on the basis that the final judgment has to come in your what do you say, the final judgment has to be concluded in your case. That is one reason. Many cases are kept pending for 3 4 years, where the authorities wait for the final judgment. Then there are other reasons that your case has been, the accused has been acquitted. So therefore, we are refusing compensation to you. But in our opinion, acquittal and conviction is not in the hands of victim. Victim has already suffered the violence. Victim has already under the trauma, and he is going or she is going under the hardships. But the direct connection or relation made by the authorities to the conviction or acquittal, which is out of the hand of victim, is given the primary source of reason for denial of compensation, which I think is very harsh.
Do you believe the Supreme Court order will bring about change? What needs to be done?
Absolutely, I 100% agree to the order that has been issued by Honorable Supreme Court, where one, they have talked about that there has to be awareness. In our opinion or in our experience, we have seen that many of the trial courts, they are aware, but there is need of sensitization, where each and every case needs to be as they discuss whether what should be done what should be done with the accused. Similarly, there has to be a rational discussion at the end, or even for granting interim compensation, that what can be done for rehabilitation of this particular victim. May it be the compensation which is monetary in terms, or may it be the compensation which is non-monetary in terms, like counseling and other relief services. But I think this kind of directive from the Honorable Supreme Court, yes, will sensitize somewhere our trial courts to think for the rehabilitation of victim of crime who comes before them as in as a complainant or as a victim, or in capacity of vulnerable children. So I think this direction will sensitize trial court. Similarly, this direction will somewhere remove the difficulty in the ground on the ground level, which victims and very very vulnerable victim and their families go through. So I think authorities will understand this concern when they will take into consideration this direction by the Honorable Supreme Court, that every victim has this right towards their rehabilitation.
Now, NewsX has started a campaign where we're going to be speaking about more such cases where compensation is pending and try to take on cases individually as well. What would you say about this campaign, Jyoti?
So there was one 25 years mentally challenged woman, and she used to stay with her widow mother in one particular village of Amravati district. And she went to her grandparents' house for one puja, and there she was with her widow mother. And as there was a puja in the village, the mother was chit chatting with neighbors, and there one of the neighbor who knew that this girl is mentally challenged, he took her beside the hut or beside their duty, and he committed sexual assault on her. And as she is mentally challenged and unable to speak, she only she could only pointed out towards the hut of that particular perpetrator, accused person, and her mother found that there was a brutal sexual assault that has been inflicted on her daughter. So this is how the case, her mother identified that she has been sexually assaulted.
Well, thank you so much, Jyoti, for joining us with your perspective on that story. We're going to slip into a very short break on that note.